Thank you very much.
Thank you. Mr. Jacobson.
Chairman Lee, thank you very much for having me here today. I oppose that part of this bill that would eliminate Part 3 administrative adjudication in HSR cases. I want to start by answering a question that you posed earlier today, and that is, why should there be a second shot by the FTC? And here's the reason. Sometimes courts get it really, really wrong. And I think our experience with the hospital merger cases in the 1990s shows that quite convincingly. So what do you do when the courts are getting it really, really wrong? Well, the Justice Department has only one avenue, which is to appeal. But the FTC is an administrative agency. And like the IRS's ability to non-acquiesce in court decisions, the FTC here has comparable authority to take the case into a Part 3 and get an administrative adjudication, which will later be reviewed by a court of appeals, but on a basis where a record can be established. There may be new theories, there may be new ways of looking at the evidence that a busy district judge who has many other matters pending just is not going to have the time to address appropriately. So I would suggest that the Part 3 process that's been in place for so long is a necessary and very important part of the basic administrative mission of the Federal Trade Commission. One of the basic premises of the bill is that the availability of these proceedings makes it harder to get an FTC deal through and concluded than one cleared to DOJ. And that's just not been my experience. My experience, to the contrary, is that the idea that one agency has an advantage over the other is a myth. The potential to commence a Part 3 proceeding can be used in negotiations. I've never heard it, but it's certainly theoretically possible. But what really matters when you're trying to get your deal through is what staff has been assigned to your deal. It's not just the clearance process, which is something the AMC recommended Congress address, and I would strongly urge you, Senator Lee, to take a look at that series of recommendations. But in terms of what really matters in getting the deals through, it's the staff, and the staffs at the DOJ are different. There are different merger shops at the DOJ. The staffs at the FTC are different. So there's no advantage in getting the deal through, which is really what the companies really care about. And the fact of a potential Part 3, which hasn't happened in over 20 years, just doesn't play a role in the negotiations in the real world. The FTC's case-by-case approach is the appropriate approach. There has been no occasion to use this authority for a long period of time. But where it is, and I mentioned the hospital type of cases, that is something where consumers are going to benefit from a careful review by the agency, subject to appellate review by the Court of Appeals, of the defendant's choice. A lot has been said about the inconvenience to the parties. It's important to recognize that if the preliminary injunction has been denied, the deal can close. Right? The stockholders get their money. The bankers get their fees, which is very important to them, certainly. There is additional legal expense, but there is no delay. And the legal expense is not different than you face in any merger context. A merger can always be challenged post-consummation. It can be challenged by the DOJ. There's no statute of limitations applicable to post-consummation challenges by the DOJ. It can be challenged within 4 years by private parties or by any of the various state attorneys general. This is an inherent risk that you get in every case, and the fact of the Part 3 proceedings really doesn't exacerbate it at all. And finally, I'd refer you to my written statement. There are some language issues in terms of the draft of the legislation, so if it does go forward, I would urge you to look at the proposed changes in my written remarks. Thank you.
Thank you very much. Mr. Jacobson, what's the best argument you can give me for subjecting certain industries and therefore certain types of proposed mergers to one set of standards and processes, and another industry and another set of proposed mergers to a different set of standards and procedures based on what we could call the coin flip of which agency happens to review their transactions?
Well,
push the red button if you will.
Sorry. As you'll see from the AMC report, I wish it was a coin flip, but it's a little more complicated than that. So why should there be a different substantive standard? I don't think there is, and I want to make clear I'm not opposing that part of the legislation. I think some clarity on that can't be unduly harmful given all of the ink that has been spilled on whether the standards are the same or different.
So you're not opposing the part of the bill that proposes a different standard, but what about the procedures?
I think as U.S. consumers, we are fortunate that the FTC has the option to pursue Part 3 administrative litigation when it's lost. As I said,
so why not give that to the DOJ?
The DOJ absolutely has that option. It's a current policy for DOJ to consolidate the preliminary injunction and merits trial, but it's not written in a statute.
They don't have administrative proceedings, though.
No, they don't. And that was, we're getting into, do we really want two antitrust agencies? For the reasons stated in my separate statement for the Antitrust Modernization Commission, I believe that plurality of antitrust enforcement is critical to the administration of the antitrust laws. But yes, the DOJ is not an administrative agency. The FTC is an administrative agency. That's been true since 1914. I do want to correct what I think may be a misunderstanding on what the Patofsky rule is. The Patofsky rule was not that we will never commence a Part 3. The Patofsky rule, which is codified and cited in my statement, has a 5-factor test to determine whether administrative cases will proceed. And really it boils down to, was the district court off the deep end? And I do think when the district court goes off the deep end, and there are instances like that taking a Part 3 is good for American consumers.
What if the Patofsky rule disappeared? What if they dropped it? What if they abandoned it? Would that affect your analysis?
I don't think they will, but it would put them in the same sort of discretionary bucket that the DOJ is, and whether to do a permanent at the same time as a preliminary injunction. As a matter of policy, I firmly support the Patofsky rule, and I would be very disappointed if it were to be changed. I think the Inova situation was an outlier, as I say in my statement, that this was attributable in part to the very strong personality of an excellent Federal Trade Commissioner, Republican Commissioner Tom Roche.
Right. But the fact that it's an outlier doesn't do anything for me. I mean, the fact that it's an outlier still exists. The fact that it's an outlier, the fact that those outliers can arise as a result of the fact that we've got two different systems, that matters, doesn't it?
I think it matters in a way that we should support, not oppose.
Okay, but you wouldn't disagree with Ms. Garza's conclusion that this undoubtedly affects parties. It affects the behavior of parties to propose transactions.
I completely disagree with that. It's absolutely not been my experience. When you're trying to get a deal through the agency, you're focused on, am I going to get a preliminary injunction or not? You are not focused on the later possibility of a permanent injunction trial with DOJ or a Part 3 with the FTC. It absolutely plays no role in the analysis.
Yeah, I want to give Ms. Garza a chance to respond to that point, but before I do that, I want to make sure I understand your answer to my question, though. My most fundamental question is, what's the policy justification for subjecting one industry to one set of procedures and another to another set of procedures? How do we justify that. You seem to be saying that the FTC's, the procedures available to the FTC are good, are better.
No, they're different. And I think the fact that they are different is a plus for the American consumer.
But if it's a plus, why not make the same, why not create a universe in which we either have two FTCs or we somehow give DOJ the ability to conduct administrative proceedings, administrative litigation?
I would oppose that because of my strong belief in the plurality of antitrust enforcement.
Right, but that's my idea of having two FTCs. Let's have another one called the Federal Antitrust Bureau. Let's just pretend DOJ doesn't exist here for a second. We have two separate ones. Would you give that other entity these same procedures? Because your idea behind the plurality of antitrust enforcement agencies, that's the idea that you don't want to put all your eggs in one basket, isn't that?
Yeah. Well, yes, and you want, sometimes there's a liberal Democrat who appoints a very interventionist assistant attorney general, but when we have the Federal Trade Commission, we have no more than 3 from one party. We have a bipartisan agency. So I strongly support that. Would I prefer two different FTCs as opposed to today's system? No. I think the system we have today with the DOJ and the FTC, they've both done remarkable things over a long period of time. I think it's worked fantastically well, and I would not tinker with it.
Yeah. I want to make clear that I'm not saying that I am opposed to differences in every circumstance, but what I am saying is that here, the reason for opposition to this legislation doesn't seem to make sense to me, and I'm struggling with the ability to understand why that opposition exists. Ms. Garza, why don't we